My name is Angela Chang, and I am the Chief Strategy Officer at KCAL Insurance Agency. My dad started the insurance agency in 1992. What started off as one man's dream is now an office of over 140 people in Southern California. At KCAL, being a part of our community is super important to us, so we take part in a lot of community events. We really have that culture of everyone helping each other, and we really strongly believe in teamwork here. We position our agency to really be a partner to all of our clients. KCAL Insurance Agency will always be there for you.
你想吃的都在饭团外卖，海量美食火速送达，超值外卖优惠享不停，肚子饿就用饭团外卖。
And we're live. Thank you everyone for taking the time today to join KCAL's webinar, Why Are Asset Protection Strategies Important? My name is Angela Chang, and I'm the Chief Strategy Officer at KCAL Insurance Agency. I'm sure many of you attending this webinar today have assets, maybe personal, business, or both. Have you ever thought about what would happen to your assets if a financial liability arises and you have no asset protection? The honest truth is, the best time to start asset protection planning is before your creditors start making claims against you. In many cases, if you transfer your assets after a claim has been made, the transfer may be considered fraudulent. Why would it be considered fraudulent? The courts may say you transferred your assets to avoid repaying the debt. Today, we'll be covering topics such as why asset protection is necessary, asset protection strategies, limitations to asset protection strategies, and learning if all assets are at risk. I would like to introduce everyone to our subject matter expert for our webinar today, Attorney Paul Chang. Paul is the managing partner of the law offices of Paul P. Chang and Associates. He has extensive legal experience in small to large business operations and commercial realty transactions. He has counseled many individuals and businesses at all levels in a variety of transactional and litigation matters. He was recently elected to the Arcadia City Council, District 4, and I am so proud to call him my friend and mentor. I'd like to introduce you all to Attorney Paul Chang. Paul, you there?
There we go. Hello. Can you hear me?
Yep, we can hear you.
All right. Well, I wanted to thank everybody here today. I'm going to share my screen real quick. Let's see. Well, I wanted to thank each and every one of you for being here today. KCAL Insurance is so amazing. They're amazing because of the fact that many companies, when they dominate a market, they get more selfish. And Kenny and Angela, what I think is incredible about them is they've decided to give back to the community in Los Angeles, in Southern California, by giving people information to be able to make them successful, whether it's with insurance or without insurance. And so many of the lectures that have been given have very little to do with insurance. However, today there's actually a pretty big segment on insurance, but yeah, I mean, I've given lectures on sexual harassment. I've given lectures on overtime, wage rest breaks. I've given lectures on intellectual property. What I specifically do is I have three main areas of law that I deal with: business, business litigation, transactions, intellectual property, internet law, real estate. Obviously, we manage and help out a lot of commercial real estate in Southern California, and labor compliance. That's a real big area. But today, what I'm going to be speaking about is asset protection. Now, I would say that this was a difficult lecture for me. And the reason why it's difficult is because in terms of asset protection, I've usually only given this lecture to attorneys. And so in preparing the PowerPoint, I thought to myself, what are the areas that typically people have problems with? And so I tried to narrow that issue for the team today, which is us today. Just very quickly, this presentation is just an outline. It's a presentation for general educational purposes, and it doesn't provide specific guidance or legal advice, although there is going to be a lot of legal terms you're going to need to know. Don't make any decisions from here for your estate planning. And estate planning covers more than just wills and trusts, right? We're going to speak about business planning as well today. But for attorneys, a lot of times we use estate planning to discuss more than just what the average person speaks about. But be real excited. There are people that are really keeping up with the KCAL lectures. I wish I could give all of them. I can't. KCAL has a number of attorneys that they can be able to use. But keep up with the lectures. I've learned so much just being part of the lectures as well. And so KCAL has just done a fantastic job. I do want to say that although I tried to make it more specific to people that are non-attorneys, this lecture is very controversial, meaning that there are going to be some things that I discuss that are very edgy, and they're not meant to push the envelope, but the reality is that there are some asset protection strategies that are very controversial. And that is the reason why you need to seek a professional before you make any decision. So I don't mean to be so hesitant today, but it's always easier when you speak to other colleagues that are in the same industry. But obviously, when you speak to somebody outside of your industry, you worry about things being taken the wrong way. But the reality is we're here to give you as much information as we can, and hopefully you can be able to learn more from it. Here's a typical hypothetical of somebody that will come into a law office or accounting firm, and they make the following statement. I just got sued and I need to protect my assets. Can I make transfers of property or money to someone else so that people cannot go after my property? Very, very fair question. Do want you to know that the relationship between you and an attorney is very different between you and an accountant. So if you tell an attorney all of your weaknesses and you say, look, I've done something that is improper, attorneys are bound by the attorney-client privilege. And what that means is we cannot go out and make these statements to anybody else. We cannot go out and testify against you. However, accountants do not have that protection with their clients. So an accountant, when you basically go to an accountant and you say, hey, I just got sued and I need to protect my money. If the accountant was ever required to testify, they would have to testify about everything that you make to them. So be very careful. We've gotten, and when I say we, attorneys have been able to get around that issue because the attorney-client privilege protects not only attorneys, but also the staff at a firm. So what a lot of intelligent people do, which is your first way of asset protection, is that you hire an accountant through the law firm. So it's a very edgy way to do it. A lot of people have a lot of concerns about that. But again, we're not making the lecture today about whether people feel that that's just what rich people do, or this is what bad people do. We're making this lecture today so that you can be able to learn. And how are we doing on the volume? Can everybody hear me? Are we doing okay?
Yeah, we're doing great. Thank you, Paul.
Okay. So that's kind of tip number one, is that if you are trying to obtain privilege, privacy privilege, one of the ways to do it is to be able to hire the staff through a law firm, because, and some attorneys will argue against it, but really the attorney-client privilege extends to both, the privilege extends both to the attorney and the staff that work for the law firm as well. So, as Angela said, late planning is always wrong. Asset protection planning after a claim arises actually makes things worse. The example that I give is that you're currently sick and you decide, well, you know what, I'm going to get a flu shot because I got sick. That's how late planning is. Late planning really is going to make you sometimes even more sick. So another problem is that people feel that if they transfer property to someone else, so I get sued, I transfer everything over to my mom. The worst case scenario is that it's going to be brought back and we're just even Steven. But that's actually not the case. There could be some heavy penalties when you do that, if you do what's considered late planning. And you become liable also for the person that's suing you, their attorney fees. So be real careful about that. Also, if you do a lot of fraudulent transfers, meaning that something happens to you and you begin transferring right away, you can lose the hope of bankruptcy. And today we're not discussing bankruptcy. Obviously, that is an asset planning strategy, but I don't necessarily think it's brand new. I'm trying to bring out brand new things for you today, taking out some of the nuggets that I teach other attorneys so that you can be able to speak with your own professional about it. Fraudulent transfer in California. This is something that is very important for everyone to learn. What is a fraudulent transfer? There are two types of fraudulent transfers in the state of California. One of them is an actual fraudulent transfer. So the definition is California Civil Code 3439.04A as an alpha, and it says a transfer made or obligation incurred by a debtor is actually fraudulent as to a creditor, whether the creditor's claim arose before or after the transfer was made or the obligation was incurred. If the debtor made the transfer or incurred the obligation with actual intent to hinder, delay, or defraud any creditor. Now, this is an intentional fraudulent transfer and it does require intent. Here are elements of an intentional fraudulent transfer. A creditor is a person or entity who has a claim against the debtor. A claim basically means really anything, right? It could be a judgment, liquidated damages, unliquidated damages, legal costs, etc. However, the third sentence is very important. A creditor doesn't need to have a judgment or a matured claim. So the definition of a creditor that a non-attorney always thinks about is they actually have a judgment against you. That's what most people think. That's actually not true. A creditor can be a person where they don't have a mature claim. You may be in a contract relationship with someone else, just working away with someone else, right? You haven't breached the contract yet, but right before you breach, you decide to transfer your assets out, then breach, take a bunch of stuff that you purchased, and then the other side can't get it. So that's what's called an unmatured claim. And transfer, it's just everything, you know, whether it's voluntary, involuntary, or you're basically just getting rid of your assets as quick as you can. And the third element is that you must have actually had the intent to hinder, delay, or defraud. Now, most people feel, well, I don't necessarily have the intent, therefore, I don't have an intentional fraudulent transfer. They have to prove that I had the intent to do so. Well, that's the reason why in California, there's something called constructive fraudulent transfer. When you hear the word constructive in anything in the law, it basically means, although you may not have the intent, we're going to say that you did do it, right? So a constructive termination means that an employee is terminated although they quit. So the constructive termination means that they were wrongfully terminated even though they quit. Like they couldn't handle the sexual harassment. You owed them a lot of money. Although they quit, it's actually called a constructive termination, meaning that it was as if they were wrongfully terminated. So therefore, if you see the word constructive in anywhere in the law, it basically means that it's as if it happened. So here it is a constructive fraudulent transfer. It's as if there was a fraudulent transfer. A transfer made or obligation incurred by a debtor is constructively fraudulent as to a creditor, whether the creditor's claim arose before or after the transfer was made. If the debtor made the transfer or incurred the obligation without receiving a reasonably equivalent value in exchange for the transfer or obligation, and the debtor was engaged or was about to engage in a business or a transaction for which the remaining assets of the debtor were unreasonably small in relation to the business or transaction, or intended to incur or believed or reasonably should have believed that he would incur debts beyond his ability to pay as they become due, or was insolvent at that time, or becomes insolvent as a result of the transfer obligation. Okay, so what does all this mean? It's kind of funny. I'm smiling to myself as I'm giving this lecture because, yeah, this isn't a very sexy area of law, if that makes any sense. It requires me to read a lot of law to everybody. This isn't like sexual harassment where I can give a lot of examples and wake people up because I'm talking about all of these, very exciting things that people wake up about. But this is very important. If you're really interested in asset protection, you got to know the very basics. You have to know the law. Some of you are looking at it on a phone. So I have my PowerPoint on a very big screen here, but every time I look at the phone, it's tiny, tiny words, but you gotta just get through it. Very important. And if you don't learn anything today, you better learn about what an actual fraudulent transfer is and what a constructive fraudulent transfer is. So in a constructive fraudulent transfer, there are some ways that you can have a constructive fraudulent transfer. So the first way is that you gave property away to somebody else, and you did not get anything of a reasonably equivalent value back. So what happens? I'll give you an example. You basically, before you get into a business transaction with somebody, you're going to go out and you're going to buy face masks, right? It's a big business right now. So you go out and buy a face mask. But what you do is you transfer property over to your buddy, right? Let's just say John. You give him your house. You say, John, take it. And then you do that because of the fact that then when they sue you, so you give it to John for free. So when they sue you, you get a whole bunch of face masks. You sell it for $1 million. They sue you. You have no assets. That's considered a constructive fraudulent transfer. So the first requirement, there's actually two parts. The first requirement is you've transferred things to somebody else. You didn't get any money back, or you got unreasonably small amounts back. You gave out $1 million house, you sold it for $100,000. And then the second part of it is there's three ways to be able to prove that there's constructive fraudulent transfer. The first way is you are about to be able to get in a business transaction or any transaction, but you didn't really have any assets left, an unreasonably small amount. Another way, which is number two, is that you reasonably believe that debts would incur beyond your ability to pay back. So it could be construed as you didn't have money to pay it back. And the third way is that because of the transfer, you became insolvent. So let's say that you had, forget about John, you have $1 million and you just gift it away. You gift away $900,000. Just gift it, right? Not even a house. You just say, here, John, here you go. I think George Clooney recently, he told a story. He gave like $14 million away, $1 million to one of his friends, or something like that, right? But let's just say George Clooney gave away $14 million. He just gave it to all of his friends, million. And because of that, he didn't really have any money left. And then he went into a transaction. Because he gave away his $14 million, he doesn't have any money left in his pocket. That's the third way to be able to prove constructive fraudulent transfer. Actual and fraudulent constructive transfers, it is a big, big business. And I've used these causes of action to be able to get back money from my clients. That's probably one of the reasons why KCAL wants me to come lecture on it because I'm probably one of the few attorneys that have sued other people and defended other people based upon actual and constructive fraudulent transfers. So this is what ends up happening if there is a fraudulent transfer, okay? One, they can avoid the transfer, meaning that they can be able to bring it back into your state. The second one is that if they can't bring it back, they can attach that estate. So let's do the example again of the $1 million. You transfer the $1 million out, the $1 million property out, they can attach it. Another one is a lis pendens. Now, here's the crazy thing. If you do fraudulent transfers, there are a lot of criminal penalties associated with them. So I just listed them for you. I'm not trying to freak you out. I'm just letting you know that there's a lot of criminal possibilities. And if you don't think people, that people just think it's a civil debt, you're wrong. There are people that have actually had penal code where the district attorney goes after them related to fraudulent transfers. And that's just for California. There's also federal as well. So why is asset protection so important? It's important because you want to protect your personal assets. You do, from any forfeiture, garnishment, or seizure. And so successful planning in advance is necessary. Planning for the future is important because the last thing you want is to work like I work so hard every single day. I'll give you an example. Monday night, I didn't get home. Sunday night, I didn't get home till 2 a.m. And I started, and then I worked. Tuesday morning, I woke up at 2 a.m. and then I began working. I work hard for my clients. And the last thing that I should be doing is having to worry. Now I'm getting close, I'm almost 50. But let's say in my 60s, something bad happens to me. All that hard work that I've done is gone. It's important to be able to protect early. How early, I think, is really up to you. But I really say the earlier, the better. If you've made now $1 million, when I was young, 1980s, you could buy a home in San Marino for $200,000-$300,000. Now people are getting paid $200,000-$300,000 a year, many times just to work. And so you have to understand that asset strategy and planning is so critical. And so what you must do is you must plan as early as possible. Now $1 million really doesn't mean as much as it used to be. Hitting $1 million as a millionaire, respectfully, is fairly easy, obviously, compared to just 30 years ago. And so I tell people that if you're about to hit $1 million of assets, I think that you should start planning early. How much is it going to cost you? It could start as low as $3,500, $5,000. Really, people are spending between $25,000 to about $75,000 to do early planning. Does that sound like a lot of money? It's a lot of money if you think about it. But in comparison to a lawsuit and attorney fees, typical attorney fees, I would say, if you are defending a lawsuit, you're pretty much spending about $100,000 on average, not on average, sometimes even on the low side, a year to defend a lawsuit. Lawsuits now are lasting between 2.5 and 3 years. With COVID, maybe a little bit longer. And so you're actually spending not that much to be able to defend all of your assets for the future, because that's really our goal. Again, when should you start planning? You should plan it now, right now. Why is it necessary? Just very quickly, asset protection is necessary because they're third-party creditors. We just learned about fraudulent transfers. Victims of malpractice or negligence. If you're a professional, being a professional, being a physician, lawyer, accountant, actuary, life insurance agent, the list goes on and on. In California, there are about 20 some major licenses Sub-licenses, there's a lot of sub-licenses as well. And, we have the most lawsuits in the entire nation. Last I checked, we're about 6.2 million a year. All of the federal courts are only about 300,000. So there's a lot of lawsuits in the state of California, a lot of opportunity, but a lot of lawsuits. Prospective asset planning can help to shield assets from premature or unnecessary losses. So here are some examples. You have family members that aren't able to make good decisions. So asset planning can be more than just protecting yourself. You can also protect family members as well. And I'm going to teach you that. Another example is, there are financial issues, drug problems, gambling problems, right? There are clients that come to me and they say, oh my God, my father, he's a gambler. My son's a gambler. My son's in drugs. What can I do? Another example is business liability. Really there are business liability lawsuits that end up occurring. Disgruntled business partner, unhappy employee, customer who slips and falls on your company. I mean, that happens too. If you don't think that there are $1 million judgments on a slip and fall, you are wrong. And you're going to end up being very, very, very poor if you think that way, financially poor, because someone's going to take you out. I don't mean to scare anybody. And I don't mean to get really relaxed about this, but too many times I see people come in, they have done so well and they are crushed by a business liability. Buying a new company, I think, is very important. Who's liable for your past debts? I mean, have you ever thought about that? Obviously, you think to yourself that when you buy a new company, the old owner is liable for the debts, but you're actually wrong. Sometimes you co-sign a loan. These are just examples. Sometimes you co-sign a loan for somebody and they end up screwing up, right? Your family goes into Medicaid. As they get older, Medicaid is allowed for a lot of the elderly. And next thing you know, somebody dies and the government's going after them. And you're like, whoa, wait a minute, right? We didn't get that much from Medicaid, but now Medicaid's coming back to us for $500,000 because of the surgery my mom had. These are all issues that are very, very important for asset planning. So, it's funny because people just don't do this enough. You have to buy insurance. Asset planning. So there's really two ways to, in terms of asset planning, what you're doing is you're trying to create walls so people can't be able to get to you individually. So you're creating these walls. Well, the first wall that you must do is you must buy insurance. So any attorney or accountant that you say, well, how do I do asset planning? And they say, well, let's look at your property. They are terrible because the first thing they should be telling you is, who do you have as an insurance agent? Let me speak to the insurance agent. Let's take a look at your policies. Let's look at what you have. There is every type of insurance that you can think of. I have even seen insurance to protect someone's beautiful feet. So I'm telling you is that, as strange as it might sound, that there is insurance out there for you that can be able to protect you. I'm not here to sell insurance. I'm not. But the first thing as an attorney I do when someone gets sued is I ask them about their insurance. If someone comes to me and they say, I want to do asset protection, the first thing I tell them is, let's get the right insurance. So although it's not my job to sell insurance, that's exactly what I'm telling my clients. So here is a problem that I frequently see when people buy insurance, and I'm very critical of insurance agents for a reason. It's a very, very competitive market. And so insurance agents have a tendency not to go over the specific terms of the insurance policy. And so what ends up happening is people, because they don't understand insurance and they don't understand the terms, they just do it based on price. So I'll give you an example. Workers' compensation. Don't you think workers' compensation covers 10 things? The answer is it doesn't. Every workers' compensation policy is different. And because the insurance agent doesn't go over the policy, many times insurance agent, what are they selling? Price. Because you don't see the value of the insurance policy, Therefore, you do it on price. It's just like attorneys. How do you know I'm good? How do you know Bob is good? How do you know Joe is good? The only thing you know is maybe a Yelp review, which I think is really ridiculous, or maybe you just go online and they have a really nice website, which I think is really stupid as well, or you base it on price. And what is a very important part of an insurance policy that people really don't go over with you? It's called exclusions, exceptions. These are very, very important, okay? So I'll give you some examples of things that are very scary. Here's some examples of exclusions that I've seen. A home insurance doesn't cover earthquake. It doesn't cover mold. It doesn't cover dog bites. So think about it. You bought an insurance policy, right? You bought an insurance policy, and that home insurance policy should cover for everything in the four corners of your house. And next thing you know, you find that you bought a house with mold. Don't you think your home insurance policy should cover it? I've seen exclusions that say it does not cover it. How about someone comes into your house and they get bit by your dog? Real cute one. I have a Yorkie only this big, really, really, really tiny. Let's say my dog bites someone. Don't you think your home insurance policy should cover it? A lot of them don't. Workers' compensation. Workers' compensation covers everything at work, four corners of the building. If your employees fight, they're at work. Does your workers' compensation cover it? Exclusions say no. Business liability. Business liability has many different types. Someone comes in, they falls, your product ends up, hurting somebody. I've seen exclusions that say trademark infringement doesn't cover it, right? Let's say that your company says, we're the best company, we have the best burgers in the world, better than Burger King. And Burger King says, hey, you defamed us, and they sue you because they got a lot of money. Your business liability insurance, if there's an exclusion for defamation, doesn't include it. Restaurants, this is a typical exclusion that I see. If you sell alcohol and someone gets injured because of the alcohol you sell, they don't defend you. So these exclusions and exceptions are extremely important. And I think what you need to do is, the solution are several. Go over the policy, right? Go over the policy with your agent and read the policy. Read it. If you don't read English, translate it, right? Spend the few $100s and you get that sucker translated. Do not buy a policy because of the price or merely because of the name. Like a very famous policy, like let's say you're like, oh, I'm going to buy Allstate insurance, right? Or I'm going to buy the insurance that has the duck, right? What's the name of that? Oh, Aflac, right? I'm going to buy it because I saw a commercial and I saw a duck, right? Aflac. No, you don't buy it just based on a name. You buy it based on the terms that are in there. 3, be willing to pay more. Do you know I have seen policies that have had all these exclusions, massive exclusions, and another policy that had very, very, very little exclusion. The difference in price, $40 a month. $40 a month. Very, very, very low for additional coverage. Another one that you should consider is to buy additional policy. You hear about the word umbrella insurance a lot. There's different types of umbrella coverage, but that's just an example, is that an insurance policy that's an umbrella insurance may cover you for things like defamation, right? These are all things that you don't think about, but you end up spending a lot of money to defend the lawsuit and attorney fees. And they're very, very cheap. Additional insurance policies are very cheap. Let's say that you buy one insurance policy, right, for, like a workers' comp policy, business liability policy, and then you buy an umbrella insurance policy. You may only be spending a few $100s more a month for you to have everything covered. So step number 1, buy insurance, read the terms, know that there are exclusions, and be willing to pay a little bit more for better policies. So here's some recommendations on family asset protection, all right? Do not transfer your property to your children while you are alive. That is a very, very big problem. There are several reasons for that. If you transfer property to your children, forget about the fact that it may be a fraudulent transfer, but your children basically have it. You know, every month I get about 2 to 4 clients that come into my office, and they always have the same story, is that they were getting old and they transferred their property to their children and their children are kicking them out. That's really bad. Yeah, and you know, unfortunately, you can't be able to claw back your property. In terms of transferring over to your children, another reason why you don't want to do that is typically younger people have a deeper possibility of getting sued. And if you transfer property to your children and they get sued and you're like, oh, I'm just going to take it back because, you know, I can, it's not going to be possible. There are still people that are going to do it. If you do make a transfer to your child, I would recommend putting a loan. You could put a low interest loan on the property and be able to record it. So it's a little bit risky, but I've seen that done, and that really kind of protects the property after you transfer it away. Okay, that's another little tip for you to think about. If you're creating a trust, and you really should, you can transfer a property to the trust in waves. So, you know, for example, this actually is worded a little bit incorrectly, but in terms of a trust, it's not written correctly. So I'm just going to skip that. I apologize for that, because for me to explain it, it would confuse you, but we'll talk about it on a subsequent slide. Another one is a spendthrift trust. The spendthrift trust is a trust that is created for the benefit of a person. So for example, let's say that you are, you know, you have a daughter, and let's just say that the daughter, she didn't marry well. You know, maybe her boyfriend or her husband is just going to spend a lot of money. Well, what a spendthrift trust does, you put the assets into the trust for the benefit of the daughter, but there's a trustee that's outside that can control whether the assets are actually going to go to the daughter or not. So that's called a spendthrift trust, and it's a really good way to be able to pass on a lot of your assets to family members while allowing a third party to control spending, essentially. However, you have to be careful is that if there is a distribution to the beneficiary, in this example that I gave earlier, your daughter, but she doesn't take it, right? She says, no, I'm not going to take it because I'm getting sued. And somebody finds out about that, there's a way to be able to break that, go into the trust and be able to get that money. So you got to be a little bit careful about how you write the spendthrift trust. Another one is obviously buying insurance and using an ILIT. You know, once you purchase an insurance policy and you create an ILIT, essentially that money is no longer part of your estate. So it's a way to be able to get rid of assets, put it away, buy an insurance policy. If you have the money, I do recommend that you just pay for the life insurance policy outright. So one way to be able to protect that, your money from litigation, is essentially just take the money, buy the policy, create the ILIT, and basically the policy is in the ILIT. It's no longer part of your estate. And so it's going to be hard for creditors to be able to go after it. That's another tip. Between married people, this is what I recommend, whether or not you are, it's between married people or whether you're advising your children, you should really use a prenuptial agreement. You know, you have to understand, California in particular has very different laws compared to other states as well as the world. So if you come from a foreign country, many foreign countries basically say that if an asset is, even after you're married, if an asset is under your name and your spouse's name is not on the name of that property, your spouse doesn't get it, because both of you guys had the intention, if you really wanted it to be 50-50, you would have put your spouse's name on there. Well, California doesn't require that. So you can go out essentially, like, you know, I'm married, I go out and I buy a house, I only put it under my name, my wife could be like, yeah, it's totally yours. But when you get divorced, she gets 50% of that. And so that's just the way California is. And so you really need to consider a prenuptial agreement. If you're married, it's called postnuptial agreement to handle split issues. Look, I know it's an uncomfortable conversation, but let me just put it to you this way. If you told your son or daughter, you're going to get married, do a prenup, and the other side says, we're never going to get divorced, why should I do a prenup? The answer is, because we're never going to get divorced, a prenup, whether you sign it, doesn't mean anything, right? A prenuptial agreement or a postnuptial agreement is something, it's really just buying insurance. So you don't buy life insurance or car insurance. You don't buy life insurance because you want to die. You don't buy car insurance because you want to get in a car accident. It's only if it happens. That's what a prenuptial agreement or a postnuptial agreement does, right? If you are going to get into a company and work with another shareholder, why do you need a shareholder agreement? It's not a California requirement. Why would you do it? Well, you do it because you want to know, particularly if we just decide to split the shares, how is it going to be split? So a lot of shareholder disputes where people are attacking and fighting each other are really because they don't have a shareholder agreement, or their shareholder agreement is written in a very poor manner. A prenuptial agreement, postnuptial agreement, just like a shareholder agreement. You don't get into business or a marriage intending to split, but if you do, how are we going to handle it? And frankly, if you have a prenuptial agreement, it makes the attorney fees very low. There's always a chance that if you split from somebody and it's very fast, divorce from somebody, it's very fast, there's actually a higher chance for you to reconcile. If you have a long divorce, 2, 3, 4 years, you're fighting about assets, you're guaranteed to never reconcile, guaranteed. So another one between married people is never use community assets to pay for anything you care about. So if you're not going to do the postnup or the prenup and you decide to put property into your name only, and you're thinking that the other side's not going to get it, one way to do it is to use non-community assets, separate property assets. So a separate property in the state of California means it's not split. So if your mom gave you $1 million, for example, and it's on the side, and you go out and you buy a home, if we can trace the home purchase through this $1 million, through the $1 million, then we can make the argument that it remains your separate property even after you get married. But I do want to say this. If the home is not purchased outright, and there's a mortgage on it, even though it came from the separate property from your mom's $1 million, the appreciation and the monthly mortgage, if you are paying that from money that both you and your wife made, then that is considered possibly a community property asset. Now, you do have to understand one thing, even if you get married and your spouse doesn't work and you make all the money, that's not separate property. It's still considered community property. And then another one is never blend the names of spouses together, meaning that you really got to keep things as separate as possible. When you put both of your names on title, when you put both of your names on the bank account, those are all significant issues. It's not here on the PowerPoint, but in the state of California, anything you get from once your family, people die and you get inheritance, that's considered separate property. However, if you take that money and transfer it into a joint account, it's arguable that that becomes community property. So please, if you get any inheritance, any gifts, really keep it under your separate property name. How are we doing in terms of time? I'm kind of worried about that. I'm never very good about time.
We're doing okay. It's 11:44, so we still have plenty of time.
Okay, so what's the stop time?
We can go as over as to 12:15 at the very latest, but
Okay.
try to wrap up the presentation around 12 and then go to Q&A.
Okay. So I always try to be respectful of everybody's time because I really don't like when people aren't respectful of my time. So in terms of incorporation, I would not, I'm not going to go over tax benefits because first of all, I'm not an accountant, although I know all the basic tax issues, but I would say this. I do see a lot of people, particularly young people, when they do business, they fail to incorporate, but they do what's called a DBA. So let's say I'm Paul Chang and I want to open up a law firm. I don't incorporate, right? I don't create a corporation. I just do a DBA because I look online, and online they say incorporate, do a DBA. A DBA is not the same as incorporation. If you do a DBA only and you do not incorporate, what you are telling the world is, although I am Paul Chang, law offices of Paul Chang, when you get sued, you're just really Paul Chang. And so you need to incorporate to separate yourself out. Most attorneys would like you to do an LLC, although it's not a requirement, but an LLC is what most attorneys prefer you to incorporate. So an LLC over INC. However, whether you do an LLC or INC, if you're not following corporate formalities, it's going to be a problem. Another way is to incorporate out of state, but there are some accounting issues that may occur, but this is something for you to research, is incorporating out of state. But when you do incorporate out of state, there are a lot more costs to do that and management fees to do that. But if you incorporate out of state, but do business in the state of California, and you don't register your out of state corporation in the state of California, if you get sued, you're roasted. It's a big problem, it creates a nightmare. Another issue that is very edgy, but I think I have an obligation to tell you so you can research, is to consider out of country incorporations. Many out of countries, they don't recognize US judgments. I do want you to know that you do have to be careful because there's laws that require you to register in the United States to let the US know that you have an out of country corporation. But what a lot of people do, which again, isn't legal, but it's very edgy, is that they have an out of country corporation, they do business in the United States, and essentially you are, you know, an employee of that out of state country corporation. And because nobody can see who are actually the shareholders, you're protected. Again, want to throw that out there because again, KCAL has asked me to just put it all out there. You can think about it. Another one is to do out of country corporations. For example, there are a lot of tech companies, what they do is they have their main headquarters in Silicon Valley. They have a out of country corporation. And there are two ways to do it. Well, all the income that's here essentially is transferred out to maximize that out of country company, right? So let's just say, I'm just going to give an example. Let's just say, boy, I don't even know. Let's just say you have company A, right? Company A is doing $5 million a year. So what you end up doing is you create a company in another country that is beneficial to you. And then you basically, because you're creating this company, you transfer $4.5 million to this company out of the country. You do that to essentially liquidate your income here in the United States. Again, I see a lot of particularly tech companies doing it. And so they do it to basically reduce their income here in the United States. All right, thank you, Kathy. We would love to send you the PowerPoint as well. So we will send you that PowerPoint as well. So you would liquidate that income through a shell entity. It's obviously more complicated. You want to make sure that you do it correctly, but there are a lot of tech companies that do that. And a lot of people think that that's a really nasty loophole. It is something that Trump was trying to close over the years. And I did think that he did a better job on it, but with the possibly new administration, we're still going to see a lot of liquidation of income going out to other shell companies, and I just think that's you know what's going to happen because it is a fight. Another one is to have a shell company that is not related in any way to your American company, but through a lot of fees and charges, there's a lot of liquidation of income here in the United States. Again, I feel so bad talking about it, but this is what I see, and I see this quite a lot. Attorneys that do a lot of asset protection do see these cases quite a lot. Again, I can't say everything is legal in terms of it being on the edgier side of asset planning, but you do see this a lot. So and you should be talking to your accountant, attorney about these issues because there's a lot of risk. Business liability concerns. When you're purchasing a business, you need to use an asset purchase. Most of the businesses that are purchased, when there is no planning involved, you end up doing what's called a stock purchase. If you do a stock purchase, basically what you're doing is you're buying all the assets and liabilities of the company. So when you do an asset purchase, you can select what you're purchasing. So if you're purchasing a business, use asset purchase because you can accept what liabilities you're willing to take on. If you're selling a business, use a stock purchase agreement because then you'll really be able to walk away from the prior business with very little liability. Always have some type of written agreement drafted by an attorney, not a CPA. If you're not the sole owner of a company and you're intending to just acquire or sell. CPAs have their own specialty, but they really don't see the loopholes to get you into litigation, meaning that they see the tax side, but they don't see the lawsuit side. So I really do recommend for this specific aspect, attorney drafted purchase and sales, I would think is a high recommendation. If you are a restaurant, please look into what's called bulk sale. A bulk sale of a restaurant essentially allows the purchaser of a restaurant to not take on the liabilities of the restaurant, but acquire most of the entire restaurant. So really look into bulk sale. Business liability concerns, always follow corporate formalities. A lot of people think that because companies are very small or there are only one or two shareholders, you don't have to follow corporate formalities. And that's really wrong. In California, it's very easy to run a company. And unless there's a legal dispute, the government's not going to come to you and say, hey, did you do this? Did you have shareholder meetings? Did you have board of directors meetings? You know, is everything okay? Are you doing your corporate minutes? They don't really come to you to do that. However, if you fail to follow corporate formalities and you end up getting sued, you're going to lose. And in terms of corporate formalities that I see a lot of times people backdating a lot of their documents to achieve corporate formalities. That's really illegal. And if you get caught doing it, you're going to lose. So you got to follow corporate formalities as much as you can, even if you're by yourself. Follow corporate formalities. Business liability concerns for employment relationships. Even if an employee settles, even if an employee quits, please give them a little bit of money when they walk away so they don't sue you. Because a lot of times employees that do want to sue their employers, they quit. The employer says, why are you quitting? They make a very good excuse. My wife is pregnant. I found another job. I'm just tired. There's COVID. And then they sue you. So every employee that goes away, even if they quit, please negotiate a settlement with them. Another one is every other employee that you intend to terminate, you want to do a settlement agreement as well. For business relationships, for asset protection, I would recommend to require mediation as a precursor to litigation. So mediate, don't litigate. And what does that mean? Is that if you're in a business relationship with someone else, whether it's a shareholder or even if it's outside, like you're purchasing product from a company, if you could put in a term in there that basically says you need to mediate before you litigate, 90% of lawsuits won't happen. And so I really want you to realize mediation is very successful. If you get a retired judge that's good at what they do or an attorney that's good at what they do, they can settle that case. And so you can save hundreds of thousands of dollars of litigation fees by essentially paying $5,000 to $10,000 to a mediator. Also, never include attorney fees if you are the party that may be breaching. So in the United States, just let you know, because a lot of people don't know this, is that if you sue somebody and there's no attorney fees in the contract, you don't get your attorney fees back if you win. This is unlike Canada. So if you're in Canada and you sue somebody, whoever loses has to pay the other side's attorney fees. That's just the law. Well, in America, it's totally different. If you don't have attorney fees in there, then you don't get your attorney fees back. So what do all the attorneys do? A majority of the attorneys, what they end up doing is they put attorney fees in there. Now, here's my recommendation to you, is that a lot of times people get into lawsuits because they feel they can get attorney fees back because it's in the contract. If you are able to negotiate, and so I've had $50,000 disputes where the attorney fees are like $400,000 or $500,000. And the reason why is each side thinks they can get their attorney fees back. Well, 93% of cases settle. When they settle, the attorney fees aren't paid back. So the question I have for you as my client is, do you really want an attorney fees clause to be in there, particularly if you're likely going to breach? That's something for you to think about and really allows you to have good asset protection if you do it in the right way. I'm so slow today, I'm not sure why. Another one is a family limited partnership. So you could research that. A family limited partnership is where family members pool money for a business project. Each can profit in proportion of their shares, and it's in a partnership operating agreement. These assets essentially leave your estate. So as far as the IRS is concerned, it's not going to be taxed against you. So these are things for you to think about. Another one is the Medicaid Asset Protection Trust. I'm going a little bit faster. I'm sorry, we don't have that much time. The general rule is as long as the trust is created, every state's different. So as long as the trust is created 5 years before you get Medicaid and you transfer over into your asset protection trust, they're not going to come after you. Look, Medicaid does not give you that much benefit, but when you have surgery, there's a lot of benefits. And so because of that, you really got to think to yourself before you go under governmental assistance, because everybody they think, oh, when I get old, I get Social Security, I get free insurance. And what ends up happening is the quote unquote free insurance, they really go after you. And so you have to be careful. And one of the ways that we do is to basically do a Medicaid asset protection trust and basically use that so that the government can't come after you get on government benefits, but you got to do it years in advance. And so I put 5 years here because really the maximum for all 50 states in terms of using that. Very quickly, I'm just going to list for you things that you can be able to research even online. Not everything I read is that accurate, but I really want you to be able to have a list of a bunch of stuff, some of which I mentioned today, allowing you to see research that you can be able to do. Formation of LLCs, corporations, family business succession plans, irrevocable trust, funeral trust, Medicaid trust, spendthrift trust, charitable trust, IRA stretch account, premarital and postmarital nuptial agreements, and more. So again, just want you to know there's no magic bullet when it comes to asset protection strategies. You're just doing your best against creditors, but it's options that are out there for you. And some of the options are very edgy and risky. Some options people consider illegal, but I guess it depends on whether you're the plaintiff or the defendant. Some of them are whether you're audited. I mean, these are all different avenues and risks that you must take. And the red part of this slide in the upper right is there's the threat, there's the asset, how vulnerable are you? And this Venn diagram in the middle is really the risk. So these are all things that you have to consider. Again, it's very rare that I say this. Most of my lectures, I say, hey, you know what? If you follow this, you'll never have to see an attorney. I would say that for asset protection, you do need to speak to an attorney in combination with an accountant, because if you fail to plan, you are definitely going to plan to fail. So before I get to the questions, I have about a minute left. I did want to say that on January 26, 2020, I was having breakfast in South LA. The reason why I mention that is because South LA is pretty far from where I live, but I really want to just kind of enjoy different parts of Los Angeles. And I heard a helicopter had crashed. It ended up being Kobe Bryant. I thought to myself, oh my God, this is my worst year ever. And what ended up happening between February to April, what we had was a wave of lockdowns. What happened between May all the way until September? Over 10,000 civil unrest or riots in the United States. October, Bobcat fire. October, earthquake. November, more fires. Our brothers and sisters over in Irvine had to deal with that. They had to be evacuated. Chino Hills had to be evacuated. In December, what did we end up having? A contentious election. Why do I say all these things to you? Because ultimately, and I want to remind you, a lot of us are looking right now at the elections and we're saying, President, please save us. But you know what? The president's not going to come and pump gas for you. The president is not going to check on your mom or ask you, hey, I haven't seen you in a few days. Do you need some masks? Is everything okay? I want you to know who is going to do that. It's your neighbor. It's your neighbor. And the reason why I share that with you is America, we are known to be neighborly. And I want you to know that although all of us are scared, and in a way, I'm kind of scared too. Every day I wake up and the first thing I do is I check my email, not for my law office, I check it for the city of Arcadia. I want to make sure that my residents are being taken care of. I look at the COVID to be able to see if there have been any deaths, how many more cases there are. I'm worried about the financials. And I just want you to know that neighbors, just neighbor to neighbor relationships, that's what's going to save us. That's what's going to take us to a better tomorrow. You know, I was just driving home the other day from work and on 300 West Lemon in the city of Arcadia, suddenly I saw a person had put up Christmas lights. It's the first Christmas lights I saw. And you know, people typically put up Christmas lights after Thanksgiving at the earliest, but I think this person did it intentionally and early. He did it because, or she did it because they wanted to remind us that the better days are ahead of us. And that what we need to do is we need to look at all the good things that have happened. There have been a lot of good things that happen. I mentioned a lot of negative things just now, but you know, in the city of Arcadia, almost 60 days straight, we had residents feeding our first responders. Every single day, we had people bringing lunch to our police and fire. All of this during the most difficult year that the US has ever faced. Every day, people brought food to our first responders, and they were so blessed, and our residents were so blessed. I want you to know that our better days are ahead of us, and they're going to be ahead of us because you are going to be neighborly and care about those that are around you. And I want you to know that before 2020 ends, if any of you want to serve your individual community and you don't know how, I will help you to be able to do that. You know, giving to the fire department is not that hard. Or the police department, there's really only between 30 to 50 employees in a city for their police and fire, and that you can be able to serve them and you can be able to thank them and you can be able to say, we love you. Thank you for being who you are. And you can make a huge difference in your own community by being neighborly. So I'm going to be taking questions. I wanted to thank each and every one of you for being here today. And hopefully you've learned about just some basics of asset protection. And let's just take it back over to Angela.
Thank you so much, Paul. We do have a couple of Q&A questions that were submitted during the RSVPs. So I'm going to read out a couple of those first, and then we're going to try to get to some of the ones that have just been asked during this seminar. So the first one is, I have a rental home under an LLC. I need to change it to my name for loan purposes. Should I and can I change it back to the LLC when the loan is done?
Yeah, so transfers back and forth aren't very difficult. My recommendation, and I say, hey, come meet an attorney, we can help you. This isn't an asset protection issue. It's really pretty easy if you just go to the title company. Title companies can typically do it for $100, $200, and so it's not that expensive for you to do. The question, though, that obviously an attorney would think is, why are you doing it? Are you doing it to avoid any type of liability? Do you have a lawsuit? If really you're not trying to avoid liability, I see transfers of property going back and forth on a short-term basis. Does it look weird? It looks weird. It's not illegal, but it does look weird. But again, my question from an attorney standpoint is why you're doing it. So, okay, next question.
So this question you already answered, but I'm going to read it out loud anyway. Is an irrevocable trust the only way to protect assets? And I think from this entire presentation, we now know that an irrevocable trust is not the only way to protect your assets. So I'm going to actually skip that one for you. All right. How can I include my rental property in my living trust and at the same time under asset protection?
So a living trust is a way to, in terms of asset protection, a living trust is not going to protect you specifically against litigation. So I've sued people, they have a living trust, I go after the assets in the living trust. So that's not for asset protection in terms of litigation. It's for asset protection for essentially two things. One is that you can direct how the assets are going to go after you die. Two, in terms of the living trust, you are able to protect it from taxes because there's essentially a tax benefit to having the living trust if you have over $12 million, basically. It's, that's really going to help you. So it sounds like I didn't answer your question, but I actually did answer your question because you actually have respectfully a flaw in your thinking on what a living trust can or cannot do.
So that also overlapped with one of our live questions that I'm going to mark Catherine's question as done. Tina's question. I'm planning to transfer all of my income properties from my name to my LLC, which is owned by my living trust. I'm the sole member of the LLC. Is there a better way to protect my personal assets?
The reason why it's a complicated question is because when people use the word protection, so ultimately the best way to quote unquote protect yourself is to not be involved in it at all. I know it sounds kind of weird, but let's just say that I buy stock in Apple. If Apple gets sued, there's no personal liability with me. Why? Because it's not under my name, although I bought stocks. And so I guess I would need some clarification on what you mean by protection. So really, the ultimate protection is it's not under your name, you have no association with it, you may get a distribution from it, but there's no personal liability. So in asset protection, we always have that question is, how do we protect people personally from liability? And so I don't mean to make it sound like it's a loaded question. It's very straightforward from your perspective. But my answer is, I'm answering a question that I created, which is essentially, if you really want to do quote unquote asset protection, it needs to be divorced from you, no control, complete. So that would be my answer to your question. But again, if you give me more clarification, I could provide better answers for you.
So that is a great segue to a more recent question that just came up. I'm going to read it out loud from Charles. My spouse has a medical corporation, but our house is held in our personal names. Is the house protected? What would be the best form for protection?
Okay, did you say there's a medical corporation, and then what else?
The house is held in our personal names.
Okay,
is the house protected? And what would be the best form for protection?
Best form. When you say, is your house protected from what? Because the reason why I asked that is it protected from taxes? Is it protected from litigation? What type of person? Is there a judgment against you? So I know these aren't as easy. These questions aren't as easy for me to answer, like when we do, business seminars or litigation seminars or employment seminars, because it becomes very, very fact specific on what you're trying to protect yourself from. So medical corporation, that's great, right? You have the proper insurance, obviously, if you're a medical corporation. You have your home under your personal name, that's fine. I don't necessarily know what you're trying to protect yourself from. If I don't get clarification, the analysis again that I have is, what type of insurance do you have, right? That's kind of the analysis in my mind. What type of insurance do you have? Do you have adequate and proper insurance that does not have exclusions that would exclude you from your needs, right? The second issue for me becomes, okay, can we be able to set up specific entities and the reasons for those specific entities depending on what type of liability you're looking at. So it looks like to me you're fine, but then again, I don't know what you're trying to avoid. Okay, what's the next question?
The follow-up was litigation for medical problems, but I think you covered it.
Yeah, if it's a litigation for a medical issue, then really for insurance on your E&O, I recommend at a minimum of $5 million. Really for physicians, I think you really should be getting a $10 million policy, but a $5 million policy is what I recommend. I understand a lot of physicians go as low as $1 million to $2 million. I think that's bad. Okay, next.
Next one, if I set up a company in Cayman, but I do business in California, what are the advantages?
Okay, so you have a company over in the Cayman Islands. Essentially, the advantages are that if someone were to get a judgment against your Cayman Islands company, that the Cayman Islands company just won't respond. There's no, they just won't respond. That jurisdiction doesn't recognize US. They could pound, US courts can scream all day, but companies like in the Cayman Islands or BVI, they're not going to care. Now, I do want to say that BVI has begun to care a lot. And so there is a risk for you to lose your protection. So that's the reason why I talk about risky and edgy. That's been happening quite a bit. So that's my answer, is that right now on a BVI entity, doing business in the US is still protected, but there are less protections than if it was about 15, 20 years ago.
All right, last question is a technical one. Does Medicaid assistance mean long-term care facilities? How about using Medicaid care for medical visits and some medical needs? Does it also have a 5-year restriction?
The answer is I don't know on that Medicaid trust issue. I typically, on a Medicaid trust, we create the trust, but then we also have other people take a look at it. So I'm not the Medicaid specialist. So we create the trust because we already have them available, and I have someone else look at it for the specific issues for the Medicaid. So it's a very technical question, but I'm very upfront with my clients as well. I don't know who you are, but that's my answer, is that I would essentially have someone overlook those issues, revise it where necessary, have an accountant take a look at it, and then we close out the case.
Well, Paul, thank you so much. I took a copious amount of notes, so this webinar was super helpful even to me. So thank you, thank you, thank you. I do have a couple of events coming up that I wanted to share with everyone. So before I do that, first I wanted to reassure everyone that if you submitted your email address upon registration, you will be receiving a copy of Paul's PowerPoint. So please be on the lookout for that email. It will include a feedback survey. Also, we have another upcoming English seminar coming up on December 3rd. It's a Thursday at 2 p.m. It's with the IRS. It's Protect Your Tax Data and Identity webinar. And the IRS announced the 5th annual National Tax Security Awareness Week, which is November 30th to December 4th. This campaign is especially timely as the holiday season brings out online shoppers sharing sensitive financial data, as well as online thieves seeking to con people into disclosing information that can be used to file fraudulent tax claims or tax returns. The goal is to raise awareness about continued data security threats posed to individuals, businesses, and tax professionals. So that's on December 3rd. And then we also would love if everyone could please follow us on social media. So here are some of our links. And if you have any other questions or concerns and feedback, please don't hesitate to reach out to the KCAL team. Thank you so much. I'm Angela Chang, and I'm looking forward to meeting with you all soon.